Hey, good morning, everybody. Welcome back to Law and Legitimacy, where I can report from Connecticut. We didn't have any blizzard. We didn't even get much snow. But, I see Freedom Lovers reporting a blizzard. He says 6 to 10 inches of snow and 60 miles an hour. Where are you at, Freedom Lover? Where are you having this godlike weather? I love winter. I love being snowed in. You used to be able to count on it back before Greta Thunberg had her way and the world went to hell. But anyhow, so cert grants today will be announced by the United States Supreme Court. They had a conference set on Friday, January 5th, and obviously you've heard they granted expedited review of Trump's challenge to his being taken off the ballot in Colorado, thus making mincemeat of Mike's and my prediction that they might grant cert and then not decide the case in the 2024 term. According to the cert grant that was announced by the Supreme Court Friday morning, certiorari was granted. And there's an expedited briefing schedule. Both sides will have their briefs in by February 8th, which is the speed of light for the U.S. Supreme Court. And I expect that case will be argued in mid-February, and I do expect now a decision in 2024. They wouldn't have given it an expedited briefing schedule if they weren't prepared to hear it right away. Other cases to watch today, I've got my eye on a case called Grants Pass. It's a case out of the Ninth Circuit, and it raises a really fascinating question about homelessness and public regulation of camping in public spaces. In other words, having people stay and establish a home in a tent or in a sleeping bag on a park bench. Um, the way the issue has been presented to the Supreme Court, and if you told me 2 weeks ago that that case was on the certiorari list, I'd say, nah, it ain't happening. But Mike sent me a fascinating story from the New York Sun. I went ahead and looked at the docket sheet, saw some 25 amicus briefs, and there is a genuine split in the circuit about what to do about homelessness. So let's think about it for a moment, and let's think about it as though we were constitutional lawyers and as though we cared about the welfare of the communities in which we live. A person arrives in your town. They have insufficient means to rent a hotel room. They have no relatives. They have no place to stay. There are not enough places in public housing or in the shelters to accommodate them. So they pitch a tent on the town green. Others come, and soon you have a tent city. Um, Query: does a town have a right to remove those people or to penalize them or to fine them for their status as homelessness or as homeless people? And if you know the Grants Pass pleadings well, you know that I've taken a lot of liberties with the facts there. The issue as presented in Grants Pass is whether it violates the Eighth Amendment's cruel and unusual punishment clause to issue civil citations to people who stay in public places without authorization. And the Ninth Circuit has held that it does violate the Eighth Amendment. And it's the only circuit to have done so. And it's created mayhem in the Ninth Circuit on the West Coast where municipal officials don't know what to do. And they argue, and I think persuasively, that when you permit people to camp in public places, you invite and welcome into the community all sorts of problems you might otherwise have not have had, including significant public health problems. In 2008, you may recall the recession, you may recall the Occupy movement that arose thereafter. I was counsel to a tent city on the New Haven Green for a while. I did their federal litigation. These
This
were
is one of my
protesters.
favorite Norm Pattis stories, by the way. You told this to me as we were walking around New Haven. I'll never forget that.
Well, so yeah, that I don't know what to do, and now not no pressure there. Now I've got to live up to your expectations. But so people protested. They put up tents on the green, and they said, "Hey, we're the 99%. We're not the 1%. We're here. We're going to protest." The courts have held that that a tent on a public space can be expressive activity that can be protected under the First Amendment. And so when the city of New Haven decided after a certain period of time that this had gone on long enough, the city announced that it was going to remove the tent city. if necessary, by force of bulldozers. And over the course of 6 months or so, 40 or 50 tents remained on the green, and 100 or so people created a community of sorts. And that community had all the problems that our general community does. There were rapes, there was violence, there was theft, and I didn't have to deal with those. There was another lawyer who dealt with that. I dealt with keeping them on the green. But as I watched them, it sort of made me confront my own utopian visions, my own visions about what's possible in recreating a society. And I thought, here are these well-meaning people who are outside the norm, outside the bounds of the law, trying to demonstrate that the law is an ass, as it were, that the law doesn't satisfy the aspirations of all. And so they're going to create a community, a city on a hill, as it were, and be an example to the rest of us about what's possible when people of goodwill can meet. It didn't work out that way. It turns out they were no better than the rest of us. And in the end, the tent city had all the problems the regular city did. And the tent city was ordered removed by the Second Circuit Court of Appeals. And ultimately, it is no more. I thought of that when I thought of the Grant Pass situation, because in the law, at least as understood by the Ninth Circuit, is that when a community has a homelessness problem, and they have X number of beds to treat the homelessness, at the point that the number of homeless people exceeds the number of beds available to treat to care for them or to provide for them, at that point the city can no longer bar them from camping on public places because they've nowhere else to go. And the result is, for cities, you've now got these lawless enclaves that are attracting people, that are perhaps creating public health problems, that are bringing violence to other communities and to stable communities. What are we going to do about that? And, it's an interesting conundrum for the law. I don't think the case is an Eighth Amendment violation. I think the better argument is that the Eighth Amendment prohibited cruel and unusual punishment for crimes. This is not a statute. These statutes don't create crimes in violation of the Eighth Amendment. And the claim that these people are being punished because of their status isn't really an Eighth Amendment issue at all. It might be a substantive due process issue. And so I don't think that the Supreme Court, if the Supreme Court reaches the issue in Grants Pass, it will only be to decisively conclude that this is not an Eighth Amendment issue. But let's think about substantive due process for a moment. Some rights that are not enumerated in the Constitution are held to be guaranteed to we the people because they are fundamental to our conception of an ordered liberty. Housing, homes, a place to stay is about as fundamental a right to ordered liberty as I can imagine. But yet there is no federal constitutional right to housing. There is no federal constitutional right to a stable home. And so I think the homelessness issue casts a light in the direction of what our common expectations are of one another, and to what degree a constitution can accommodate those common expectations. And the issue becomes poignant given the pressure on our borders right now with respect to immigration. Because as millions of people flock to the United States, perhaps as a result of climate change or other instability in Central America and elsewhere in the world, are we going to be able to say there's no room at the inn? Or, consistent with the Ninth Circuit decision and others like it, are we going to be told that as a matter of law, a person who arrives has a right to housing? A person who arrives has a right to minimal conditions of existence consistent with a stable conception of an ordered society. That's on the one hand. On the other hand, people might be saying, well, wait a minute. We never said we were going to be the innkeepers for the world. And at the point that the 10,000th person arrives to stay on the town green, do we have a right to say no mas? No more. We can't tolerate anymore. We can't handle anymore. I'm not sure the law gives answers to that. So keep an eye on the Grants Pass decision. I think if cert is granted, it'll be on the narrow Eighth Amendment question, and the court will conclude probably 8-1 or 7-2 that this is not an Eighth Amendment issue, but invite reconsideration of it on a substantive due process grounds. Other petitions, I'm not sure what other petitions I'm watching. I've got two petitions that were listed on Friday. One involves a man named Titus Thomas, and it involves the use of informants' testimony. I'm not sure that the court will grant that petition. We thought the issue was significant enough to raise it. A second one involves whether qualified immunity can ever be granted to a state official who serves a bogus warrant. I hope the Supreme Court does grant that case. It's called Doe versus Pisani, and the facts in that case were state officials took action against a man on claims that he had abused his children. He hadn't, in fact, and the warrant that suggested he had contained misinformation. When the criminal case was dismissed, he sued the officers, and the court said that there was arguable probable cause, even if there wasn't probable cause at all. The Fourth Amendment doesn't say anything about arguable probable cause. It says
It's
no warrant shall issue without it. And so we've got our hopes.
I've got some serious concerns about the City of Grants Pass case, just with the downstream effects, and um, I'm teasing this idea of some sort of neo-feudalism that we're walking into, sort of silently, Norm. And I think about the minimal standards or conditions for accommodations if it became the case that if one did not have a home or was otherwise did not have somewhere to go, that the public writ large was required to subsidize uh, large populations of homeless people, and what that means for property rights, what that means for the growth of government writ large, and what it means for staffing of administrative agencies, no doubt, that would be tasked with managing this, and the fact that we are right now considering a solution to a problem that is only treating a symptom thereof. It acknowledges nothing about the existence of a standing homeless populations, the minimal conditions for activating people in their own individual right to seek employment, to find fulfilling life, and also why it is that in 2024 and beyond, we are living in a culture with such low morale that we would seek first to try and house, the 40% or 60%, whatever the statistics are, of homeless people that do not have somewhere to go, rather than working backward to figure out the anatomy of the problem. What role mental health has played, what role government has played in, I don't know, offering. I think back to the opening weeks of the Biden presidency, where we had free needles and clinics being opened, encouraging use of illicit drugs rather than figuring out a way to treat the spirit of Americans and encourage them to find more within themselves than to be some sort of feudal peasant on some sort of large government backed landhold estate.
Yeah, I don't know. I don't know. I hear you, Mike, and it's an interesting perspective. I have a slightly different take, and that is, I view obviously constitutional order as a thing of vast mystery. How is it that we get along with one another? What stories do we tell one another to adjust our expectations about living in a community? How do we harness the power of the state such as to claim that there are authoritative answers to our common problems? And I think a constitutional order sets broad limits on that meets and bounds, or on the meets and bounds of how we resolve those problems. And I'm not sure that our Constitution is self-legitimating. And so when I view people in homelessness communities, I view this as the state of or vast numbers of immigrants coming into the United States. I view this as the state of nature. This is a place where the recognized limits of government are not recognized. These are people outside the bounds of the communities that we've established. How do we bring them in? Do we bring them in? And if we don't, what do we do with them? I've
Well,
heard
and
some.
let's not be, I guess, distracted by the likes of someone like Gavin Newsom, who is concerned about being able to remove homelessness encampments and using government force to remove people from these areas. Someone in his position really is only concerned with his ability to accommodate some sort of foreign diplomat and work swiftly to relocate people for optics rather than actually solving the problem. And again, I'm very critical of this because I don't think that we're framing it. Not you, Norm, but I think the framing of this issue is severely lacking. I do listen to quite a lot of Adam Carolla and Dr. Drew on their separate show. And Dr. Drew, as a physician, he is a specialist within the mental health field, and he has been talking openly about this issue and the lack of government competency or real motive to solve the problem of homelessness. And to me, this is sort of yet another sort of red herring with respect to sort of growth of government, right? We're talking about people. It's easy to be emotional about these issues. You've got the left that seeks to control and command language around this, houselessness, experiencing houselessness, stuff like that. And I was very critical of that on Friday. I'm still very critical of that because we should expect more of our fellow man. And that's not to say that the exceptions don't live out there, those who have fallen through the cracks. However, when you have hundreds of thousands of people and the growth curve is such that we are watching homelessness increase exponentially, which we are right now, there's something else broken. And we should not be seeking to build permanent infrastructure, both economically and physically, to account for the symptoms of a problem that we have no plan to actually solve.
Point well taken. Hey, let's pivot here to the Ashli Babbit lawsuit. It took some time, but the estate of Ashli Babbit has finally filed suit against the United States government. They filed under, and you'll recall Ashli Babbit was the young woman. I believe she was 36 years old when she was killed on January 6th at the Capitol. She was killed by a Capitol security officer who shot her as she was entering a broken window separating a hallway from the one of the galleries, whether it was the House or Senate gallery, I don't recall. One shot dropped her, and she died almost immediately. This was almost a little bit more than 3 years ago. So her estate and husband sued under the Federal Tort Claims Act. They sued the United States government, and that writ, I guess, was filed last week. I'm looking for a date on it here. I don't see it,
Yeah, I think
but it was
this would have been January 5th,
okay. So it was filed in 19
Friday.
or in 2024. Um, just a couple words about the Federal Tort Claims Act. It when you see, you have you can the United States government is immune from suit except when it consents to be sued. It has what's called sovereign immunity. Under the Federal Tort Claims Act, a person can bring an action against the government, making certain claims, including claims for wrongful death or for unreasonable force. What I found particularly interesting about the Babbitt suit is they didn't sue under the 42 United States Code Section 1983. They
Mhm.
didn't sue the shooter, whose name I don't recall.
Lieutenant Byrd.
They didn't sue Lieutenant Byrd in a so-called Bivens action, and that's a claim where you sue an individual acting in his a state actor acting in his individual capacity, and you ask for money damages against that individual. The government typically defends such an individual and indemnifies him for any losses that the plaintiffs prove. In this case, the estate took a tack that surprised me and it brought largely set of negligence claims against the United States, claiming that Byrd acted negligently when he was an agent of the United States, that he acted negligently when he shot Miss Babbitt, that he was inadequately trained, and that this is the fault of the United States government. Um, the defense will be that he behaved reasonably under the circumstances. Babbitt's lawyers contend that he didn't, but they cited the lead cases, Graham versus O'Connor, for example, Payne versus Tennessee, which basically holds that there are substantive limits on the amount of force that a state actor can use when confronting a citizen, and that it has to be reasonable. You have to believe that there was an imminent risk of death or physical harm to another person, and that your action was a reasonable response to prevent that. So keep an eye on that lawsuit. Passions run high regarding the Ashli Babbitt death. Many in the J6 community call it a murder. That is an unjustified taking of human life by the Capitol Police officer of this protester. Others have praised the officer as having saved lives by deterring Babbitt and others, in her stopping Babbitt, and thereby deterring others from flooding into the Capitol galleries in ways that would have permitted them to cause harm to lawmakers. The federal court of the federal claims court is a separate court. It's a court in Washington, D.C. Expect the government to file a motion to dismiss. And I suspect that the government the government will win that motion.
I don't
I
think that they'll win a motion to dismiss. I do like unpacking and, negligence suits for our listeners, Norm, because we get to, impugn the reasonable person standard. But that's what this case largely is based on. There is an assault and battery claim pursuant to that Federal Tort Claims Act that you referenced at the beginning, but negligence is, by an element's perspective, is duty, breach, causation, and damage. And obviously, the damage here is what leads. It leads in every case. We have the taking of a life. And so in knowing that the damage is there from a civil perspective, there are all sorts of categories of monetary damages and other relief that a court may grant. But the duty is what is going to be the most important here in terms of a of an evidentiary and a legal perspective. Um, the reasonable person standard says something to the effect, if we're just talking in common law principles, that you have a duty to act as a reasonable person under the circumstances. What I have on the screen here, though, Norm, you'll notice that the and I think it's Judicial Watch who has brought this on behalf of
It
the
is Judicial Watch, yes.
and so that's I think a sophisticated party. They're no stranger at all to lawsuits, and I think that that's meaningful. And I also like that what they're doing is they are attacking the element of duty to make the breach an easier showing, and you do that by raising the level of duty. So in this circumstance, it's not an ordinary standard duty of care, right? A reasonable person under the circumstances, what they're going to say is that Lieutenant Byrd was a part of a department. He had an elevated standard of care. He was held not only to that of a reasonably prudent police officer, which you see there on the screen, but that he had enhanced training and he had enhanced obligations, and therefore his duty was far more than that of a normal standard duty of care. And the breach in this case would be any derivation therefrom cast as unreasonable. And what they did in this lawsuit, Norm, is talk about instances of his conduct over the last several years that have involved firearms, right? Namely, him leaving his firearm in a bathroom in the Capitol building that was retrieved by some sort of routine sweep before. I think negligent discharge in the past, his reputation among his peers for being incompetent and worse. And what they're going to do is impugn his reputation and what he did as something that would have been reasonably foreseeable, right? Because that is what the standard here is the defendant here in the United States government, was it reasonably foreseeable that an act such as this could occur under these circumstances? And if so, what did you do to mitigate? Are you to blame? Are you the cause of that? So, actual and proximate causation. Those are going to be the big burdens, I think, for the petitioner here as well, the estate. But I don't think that in a situation where we're talking about damages, they allege 30 million. Negligence actions are famous for this. It's either you're in a contributory negligent state or you're in a comparative negligent state. I don't know the answer to this question, but I know North Carolina is in the extreme minority that still abides the contributory negligence standard. That is, if you, as a petitioner or a plaintiff, are at all negligent in bringing about harm to yourself that you claim, that is a complete bar to any monetary recovery. In DC, I'm almost 100% certain that it is a comparative jurisdiction, meaning, Norm, that even if Ashli Babbit was partially to blame for her own, if this is what the facts and the case bears out, even if a jury finds that Ashli Babbit was in some proportion to blame at or below 50%, her estate will still get some of the money.
So I
So
think these
it's
are,
a pretty,
it's
pretty low
I'm glad.
target.
It's low and it's not. I mean, here's the problem: as Mike points out, there are four elements to a negligence claim. Duty. You have to you have to have a duty to another person. There has to be a breach of a duty, a departure from what the duty requires. As a result, that departure from what the duty requires has to result or proximately cause or nearly cause injury to another person, and then you have to prove the extent of your damages. The loss of life, obviously, is catastrophic. In the case of an officer using force, I remind our listeners that the state has a monopoly on the legitimate use of force. It's not an idea that I came up with, it's Max Weber's idea. And it is the very essence of a state to have such a monopoly. We train police officers on the use of force and authorize them to use deadly force. In other words, we claim that in certain circumstances, deadly force is reasonable and justified. And so in this case, the government will come out saying that Byrd's conduct was justified, that given the imminent threat that the riot posed to the safety and security of those whom the officer was protecting, his use of force was reasonable. I think reasonable minds can disagree about that. I think that Tom Fighton's Judicial Watch's petition talks about his need to give warning. He should have taken intermediate steps before opening fire. That's not the law in a Fourth Amendment context, and that may be why Judicial Watch brought a negligence action rather than a civil rights claim. Because on a Fourth Amendment standard, it is likely that Babbit would lose the case. And I expect the government to try to defend this on Fourth Amendment grounds, to incorporate the law of reasonable force and unreasonable force used in a Fourth Amendment context and graft that onto the common law context. I don't know if they'll succeed or not. I don't have, I mean, I've been involved in any number of deadly force cases arising from the federal constitution. I've not done them as negligence cases. I don't know if the negligence net will sweep more broadly. I do know Ashli Babbitt's mom. I got to know her during the January 6th cases and have stayed in touch with her. I wish her all the best in this lawsuit, and I wish the estate all the best in this lawsuit. I thought it was obscene that Bird was never held accountable, meaning put on trial in any public context so
Yeah,
that the public could
charges
evaluate
were
his
declined.
conduct. I
Charges were
think that
totally fine.
now, I think when the state uses deadly force, it's doing so in our name. And my view is in each and every case when deadly force is used, there should not be a motion to dismiss. There should not be a summary judgment motion. The community in general should have the ability to sit and at least see in public, in a court proceeding, what happened so that it can make a decision for itself whether the state killed in its own name and whether whether when the state did kill in the name of the public is happy or satisfied with the result. So let's keep an eye on that. It'll be an interesting one. Again, my prediction is that it will not see trial. I hope I'm wrong, but I've had some experience in the federal court of claims and know it to be a very conservative institution. Hey, can somebody tell me what the hell's the matter with Elise Stefanik up there in New York? I mean, I saw a story this week. Apparently, she's a member of the House Leadership Committee. I like the work she did taking on Claudine Gay and other members of the Hamas community colleges at Harvard, MIT, and University of Pennsylvania. But apparently, she was interviewed over the weekend, I think on Meet the Press or Face the Nation, and she was asked whether she would commit to certifying the results of the 2024 election. And she's already talking about problems in an election that hasn't even taken place yet. I mean, it's obviously one thing to take a position on whether Trump should be on the ballot, but it's another thing to double down on the failed rhetoric of 2020 on the cusp of the primaries. I mean, we haven't even begun the presidential nominee selection process in any official capacity. And already Stefanik is waving a bloody flag, suggesting that 2024 might be more violent than 2021 or 2020 was. And I find that a little bit chilling. I mean, I don't know if you saw her remarks, Mike, but
Did
somebody needs to.
I didn't see it, and Elise Stefanik is involved as well in the Claudine Gay removal as well. Is that
Right,
correct?
right. Yeah.
She's, I guess, famous as of late for her cross-examination or her
She
examination
did a good job. She
of
did a
the
good job with
private
Gay.
residents. I think I'm going to decline an opinion until I get a chance to actually hear what she said. But I am doing a quick search here, and all of the notable standard media outlets are saying roughly the same thing, which is that she is declining to certify to certify the results of 2024.
I mean, she's declining to commit to certify the results, no matter what they are. And in one respect, that's an obviously correct answer. You can't certify what hasn't happened yet, and let's see what happens.
That's right.
But she's suggesting already and sowing doubt about the integrity of elections that have yet to take place. And I regard her comments as profoundly delegitimizing. It seems to me that if we're going to come together as a people and learn to live together as one and have joint expectations about and settled expectations about the communities we live in, we need to come together at a minimum about how elections are to take place and how they are to be regarded. So, Elise, rather than running your mouth about what you're not going to do or commit to do in 2024, how about using some of the clout you acquired in your takedown of Claudine Gay and lending a voice to what it'll take to have sensible federal election reform? I think Vivek Ramaswamy has been making sensible calls for voter registration and what we should require of people to vote. I'd much rather see Stefanik get behind Ramaswamy's comments than start waving a bloody banner and suggesting we're going to need another January 6th this time in 2025.
I agree. I want to, before we get out of here, Norm, last thing is to tell everybody again to subscribe to the newsletter that is forthcoming and to also show that we've got something new as of this morning. It's Norm's What We're Reading. Norm, you've been reading a couple of things. One is The Giver, and you've got a quick blurb there uh, charging people to give that a read if they have not. And then you've got America for Americans: A History of Xenophobia in the United States. Anything to quickly recap there?
Yeah, The America for Americans is a great book. I'm an Islamophobe, and you've heard me talk about how I view Camp of the Saints is not a racist screed, but a sort of allegorical warning about the dangers of too many immigrants too quickly. When you read Erica Lee's book, you realize what you come to realize is this is old rhetoric in the United States. The very words out of my mouth were used by Pennsylvanians in the 18th century to complain about, in early 19th century, to complain about too many Germans. They were used to complain about too many Irish when the Irish came over from the potato famine. They were used to complain about the Chinese on the West Coast and the Alien Exclusion Act. And so throughout our history, we've had a xenophobic tendency to regard the other as a threat to us. But yet, in each of these prior waves, we've managed to incorporate the previously threatened group to become a broader and greater people. I'm not so sure I believe that about Islam, but the Lee book has me reading carefully and questioning my own beliefs and my own rhetoric. I would recommend it to each of you. It was written in 2021, and I think it's an important book for our times. As to The Giver, that's a book Mike asked me if I'd read, and I thought I had, and then I picked it up and realized I hadn't. Wonderful book. If you think that love is overstated, it isn't really the answer to everything, you're dead wrong. Take a look at Lowry's The Giver. If you don't love the book, call Mike and I will buy it back from you, and I'll sell it in my used bookstore. We've also got essays coming out soon. I sent one to Mike the other day. I remind him of this to tweak him to get it up there. We want to engage you. We want to try to create a written corpus of work that you can look to as commentary on our times and hopefully respond to us and let us know what you're thinking.
That's right. And I think the first essay that we will be publishing that you sent over the weekend, Norm, is in regard to the uh, Pizzagate / Epstein client list, that story that we discussed, I think Friday of last week. And
Thursday or Friday.
we've had a few comments on YouTube and otherwise with some level of disappointment from some of our viewers saying that there is some smoke here, Norm. So I'll make sure to get that out probably Wednesday of this week. We've had a pretty overwhelming response to our newsletter sign up, so I'm really happy to see that. Thank you all for signing up. And if you haven't yet, it's really as easy as I've got on the screen, lawpoddaily.com. Drop your email there, subscribe. I'll pull it in, and we will begin publishing these essays via the newsletter this week, and we'll try to do that at least once a week moving forward.
All right, and we did a long form. We'll tell you more about that later. But Mike, I got to run to court. I've got an hour and a half to get to it, to get to Danbury on the other side of the state, and it's snowy over there, so I better hit the road. All right.
Sounds good to me, Norm. Thank you. If you have not yet, follow us on X. We are at Law Pod Daily. You can find us here on YouTube, on Rumble, on X at Law Pod Daily every day, Monday through Friday, 8 a.m. Eastern. You can also find us on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. And the only thing that really matters is that you enjoy it, you give us your feedback, and that you perhaps share with one person, right? Tell a friend and have them come stop by lawpoddaily.com. Norm, I will see you tomorrow morning. Bye, everybody.
You will. Bye.